notice and that opportunity to be heard, but each one, again, is different. The grievance process that Bessie suggests is that it needs to be 15 days after the evaluation, and that there's to be a written response and a meeting between the evaluator and the evaluatee. But it also references that the teachers to pursue the local grievance process. So in this case, and with so much at stake, it really kind of muddies the waters, and hopefully we'll have some better understanding of what that process needs to look like by the next school year. I talked with them, and they said that they were looking into that and to make some revisions so that this meshed better, so that you knew what that grievance process specifically should look like. The evaluation, according to Bessie rules, is to be conducted in a fair, objective, and consistent manner. And of course, your specific grievance process matters. Anybody can grieve an evaluation. Those of you who are not tenured, you can grieve yours too. So for reasons that we'll explain in a second, I highly suggest that you know that this is oftentimes where I think now you need to understand that your due process starts here, in my opinion, rather than later with a potential termination. Because at that point, in some circumstances, and because of reasons I'll explain, it may be really, it's already happened. The evidence to support the termination is already in existence. All right. So quickly, the Bessie, we can just do this. All right. Prior reasons for removal of a tenured teacher were willful neglect of duty, incompetency, dishonesty, immorality, and being a member of a group that's not allowed in Louisiana. That list, I don't think you guys are going to have to spend a whole lot of time on that, right? Because you're in there doing what you're supposed to do. And when you read the case law that supports these prior things, and this is why people have had this idea in their mind, like tenure, nobody can fire a tenured teacher. Because you've got to be really, really, really bad. That's why. And that is where that sort of idea, I think, in people's heads has come from. Tenure means that you never can be fired, because you've got to do some pretty egregious stuff. And when you look at the case law, it is pretty egregious stuff. All right, they've added now to that list, and it adds poor performance. And that's what is sort of like, oh my word, now poor performance is on the list. Well, how do you prove poor performance? Because y'all are good performing teachers, right? So you don't have to worry about that. But that's where poor performance, do you see where poor performance is a little bit greater than some of these other things? The law states clearly that the evaluation results of ineffective, in and of themselves, are sufficient proof of poor performance. What that means for the lawyers is that all they have to do is take the ineffective rating, and it's a done deal. We don't talk about how hard you worked, and how good your kids were, and how good a teacher you were, because that ineffective rating is an automatic, substantial evidence of poor performance. Is everybody understanding now why our due process starts back at the grievance stage? So, and even if you're the type that says, I just don't want to call, maybe something that we, look at. Other than that, the three people that make up the tenure panel are the designee of the superintendent, a designee of the principal, where the person is employed of that campus, and a designee of the teacher. But it can't be a family member, and it can't be a full-time employee of the school system by which the teacher was employed, was under the supervision of the person making the designation. I haven't figured out yet who the superintendent designates, because it seems to me that this says you can't designate a subordinate. And I understand that the idea is that you can't, then you could control. Like if the superintendent says, I want to fire you, then you would say, okay, well, if you designate somebody to be the appeals panel, you're going to designate somebody that's just going to go along, and you can't designate a subordinate, because then they have to do what you want. But who is subordinate to the superintendent? So I think there's so much gray here. Anybody who comes in and tells you they know all about Act 1, it's awful, this is what it says, that I just don't think that's true. I think there's a lot of things that are going to have to be worked out before any running from the hills needs to happen. All right, that tenure hearing is private unless you request it public. I feel like personally that if you were, done in and you have all these highly effective ratings and all of a sudden this random ineffective rating because your son beat out somebody's son on the baseball team, they're saying that it could be for any reason, they could just not like you. I would ask for it to be public then, right? That's a right you have to waive your confidentiality rights. Ask for it to be public. Let's all hear the charges about me that aren't true, because everybody knows that, right? So that's a very, very effective way to handle things when they're just not being done right. It shall begin within 7 business days after the